Okay, so let's have a look at this. We're talking about this really important idea of judicial precedent. And when we look at law, if we can put this in the bigger situation, we've got two lots of law. We've got the Parliament-made law, which we've looked at. That's how bills get passed through the Parliament. In Queensland, we've only got the one house. In Canberra, we've got the two houses of Parliament. And a bill goes from being a bill, introduced, voted on. If it's voted on, it becomes an act of Parliament. So that's how laws are made with the parliamentary process. Now we're looking at judge-made law. And this is about precedent. And the idea, the basis of it is that judges are obliged. That means they have to follow the decisions of earlier cases in cases where the courts are of equal or higher and the facts are substantially the same. So I gave that example of Wes. And don't copy it down now. We'll go back and have a look at these later on. Just get a sense of what's going on here. I gave the example of self-defence. If there was a case that had happened and someone had defended themselves and the facts then were later on were similar, they'd look back to the judge's decision in the first case. So it has to be on cases in equal or higher courts. So a district court judge would be bound by a decision of a previous district court judge or by a Supreme Court judge, but not by a magistrate, because that is a lower court. It establishes a pattern to be followed, and it's all about increasing consistency. They show the way for us in legal studies, the way that previous circumstances, previous judges' decisions influence the current situation. And that's really important when laws are developing. So things around cybercrime, for example, or online bullying. There have been cases, one recent case where a person took their life after some online bullying, and the judge had to make decisions around to what extent were the people who had done that online bullying responsible. And so that becomes a really important precedent for cases that are going to happen in the same level of court, or if the case happens in a lower court. So when you're thinking about whether something is a precedent, whether a case is going to act as a precedent, you've got two questions to think about. Is the earlier case, the possible precedent case, is that in a court of an equal or higher rank? So if you're in the district court, you're having your matter heard in the district court, you could use a case from a Supreme Court or the district court. You could not use it from the magistrate's court. You could use it from the High Court. And are the facts substantially the same? We talked about an example of self-defence. Are the facts substantially the same? For example, they might be considered to be different enough if the person entering the private property was armed, and in another case they were not armed. You might say, well, no, we will differentiate on that. We'll distinguish those two cases. But if the facts are substantially the same, then they'll look at that case. We just looked at the court hierarchy, right? This was why this revision question was on today. It's because it really matters in precedent, because as I've said, precedent happens from cases that are similar or higher in the same court hierarchy. We talked about our link to England, and they've always been important in the link in the development of Australian law, but now they've abolished that appeal to the Privy Council. We're no longer part of the English court hierarchy, so it's no longer the same court system, so it's no longer binding precedent, and so it becomes less important. When we looked at the court structure, we said there's two different types of cases. I didn't actually use the fancy words, but here they are. The courts where you hear the case on the first time, that's their original jurisdiction. For example, if I'm suing someone for $400,000, we know that's heard in the district court. So that's the original jurisdiction of the district court. But if there's appeal in that case, if someone thinks that the matter hasn't been heard properly, it's heard in the Court of Appeal. So that's their appeals jurisdiction, or the fancy word is appellate jurisdiction. And this is important in thinking about precedent. When a judge makes a judgment, they have to give the reason. They can't just say that someone's guilty and they're going to go to jail for 10 years. They have to give the reason why. And we have to distinguish between the two parts of their reason. The ratio decidendi, which might just be shortened to ratio, that's the core reason. The legal principles for making that decision. We talked about that self-defence case. So the judge might say this person is not guilty of self-defence because their actions was consistent with a reasonable threat. Right? They were reacting reasonably to the threat. And so that's the core reason. They might also make some statements by the way. obiter dicta. So, for example, go to that self-defence. I've had a person come into my house that was armed. I've whacked them, and the judge has found that I'm not guilty because there was a threat. My reaction was reasonable because the person was armed, had broken into my property. They might say, though, some other comments. They might say, however, if that person had not been armed, it was not reasonable for me to use that level of force to deal with the situation. So those are extra comments. Comments, by the way, they're the obiter dicta. And it's the ratio that's the part that is binding another court. So you have to be able to find that key reason for the decision, and we will look at that later on today.